Further hearing in the Mitsui Co Ltd and other shipping appeal.
Well, my lords, having introduced the appeal, let me, if I may, take you to some of the relevant facts. We looked yesterday at the contractual framework, albeit briefly. The details emerge from the adjustment, and I don't need to take you to those. But there are some features of the facts which are important. They're important before you for two reasons. The first is that my learned friend makes some criticism of the way in which the Court of Appeal approached the facts. So I just want to show you some of the features which he's critical of. And secondly, my learned friend has a case which says that if choice is a requirement, well then his clients in fact made a choice. And to understand that submission, one needs to have a little bit of an understanding of the facts. Now, I'm not going to go all the way through a statement of facts and issues, because you have that, and that's an agreed document, and that can be taken as read. I just wanted to pick out one or two points, and one can do that, I hope, conveniently by looking at a passage from the attached to the adjustment. It is the ransom consultant's confidential report. It's in the core bundle. It's behind tab 8, sub-tab 5, and it starts at page 263.
Yep. Thank you.
You may or may not have already seen this, my lords. In a sense, it needs to be cross-read a little bit with page 260 and 261, which is this statement of facts. But I just want to pick out one or two features from 263, if I may. The first is, of course, we know that there was the hijacking which takes place relatively early on the 29th of January. And after the hijacking which takes place off the coast of Yemen, the vessel is then effectively proceeds to just off the coast of Somalia in the Isle area. And I'll return to that in a moment. In response to the hijacking, we see at the second paragraph, Mr. Gantz is appointed by owners as their designating person ashore and security officer, and the relevant underwriters, that is to say the owner's underwriters, appoint Mr. Valadez of NYA, who is a specialist ransom consultant. And what we're looking at here, my lords, is Mr. Valadez's confidential case summary report. And that all happens on what this document describes as he's appointed on CD2, the second day after the incident. We'll see that at the end of the second paragraph. On that same day is the first telephone communication between the pirate communicator, Yusuf, in which he makes the initial demand. And that's, if you like, when the clock starts running for my learned friend's case on operating costs. We can date that by reference to page 260, not just date it, but time it, because at 260 we can see that took place at 14:05 on the 30th. You see that about halfway down that page. And in that conversation, as well as there's a demand of 6 million, Mr. Gantz spoke also with the captain of the vessel, and there was a report that the crew were all well, with the exception of one who'd been wounded in the firefight, and the cargo was stable, but there was a note that the inhibitor would expire. And then we see at the end of that paragraph, on the next day, Yusuf presented a new pirate negotiator, Lu Yan. So we're now on the 31st of January. And then beneath that, we see a passage marked initial negotiations. And this is, UG is Captain Gantz, my lords. He says to the pirates that the demand was too high. He would not be able to present an offer until he met with owners. And both Yusuf and Lu Yan assured Captain Gantz that the pirates wanted to settle as soon as possible. Now, it's not crystal clear when that conversation takes place. It looks like it probably took place on the 31st, because only at that stage has Lu Yan joined the ship. But it's not crystal clear. But what we can see is it takes place before Captain Gantz has had any consultation with owners. He's not met with owners, that's what he says. But he is saying there, my lords, clearly, what you've demanded is too high. He's inviting a negotiation, and the pirates are indicating that that's what they'll do.
What is the conclusion of fact for which you are arguing by reference to these documents?
What I want to show, my lords, is that from the outset, these ship owners did what every other ship owner has done in this situation, and took the course to negotiate, to agree a ransom figure for the release of the vessel. And that negotiation involved not simply a negotiation to obtain a release, but a negotiation as to the amount of ransom.
Yes, well, is there any dispute about that?
Well, there is a suggestion, as I understand it, that a positive choice was made by ship owners to do that rather than yield to the first ransom. But there was a point in time when they...
This is slightly metaphysical, isn't it? Because, in a sense, I mean, it's obvious there was a choice. They decided not to, and they rejected the pirates' demand. Now, I mean, you could say, if the pirates' demand was, for example, objectively unreasonable, then you could say they weren't really faced with a choice, because if they'd accepted it, they wouldn't have recovered it in general average. I mean, there was obviously a choice as in a sense, but that's where there may be a slight inconsistency between the court's findings below on the two issues. In saying that there are two reasonable, as soon as they say that it would have been reasonable to accept the pirates' initial demand, doesn't that present the choice? Because by rejecting it, you will...
Well, I do follow that entirely, my lord, and one perhaps needs to see what the Court of Appeal is saying on that second issue and whether they're actually treating the second issue as one that arises on the factual assumption.
I mean, is the point
that's what was done and could be done.
Is the point that you're trying to make that they never sat down and said, now, which of two courses shall we adopt? Shall we pay up at once, or shall we tolerate the necessary delay for the purpose of getting it down? So it wasn't, so to speak, an express piece of analysis, because, I mean, I find it extraordinarily difficult to regard that as the test, but is there any suggestion that they did actually sit down and articulate to themselves?
Well, I don't know if there is. My learned friend relies on a paragraph in, I think, Mr. Reapon's witness statement to say that a choice was made. And he referred you to that yesterday. Yes. I don't know whether he is saying that the sort of process that you've just suggested, my lord...
Well, it's obvious that a choice was made, because there were two alternatives, and one of them was selected. But, I mean, is it suggested that they actually expressly analysed the choices?
Well, I don't suggest that.
Well,
what I don't understand is whether my learned friend suggests it.
Yeah, but does it? I think
matter.
Why does it matter? We make instinctive choices without thinking about them all the time.
May I say something? I would prefer it if my learned friend were addressing you on these points by reference to the agreed statement of facts, which sets out in precise sequence what happened and when people were said to have considered whatever they considered.
He must address us as he sees fit, but I can understand your point that he is, as it were, arguably bound by the statement of facts.
yes.
And I'm not seeking in any way, my lords, to go beyond the statement of facts.
Let's just concentrate on the essential point. What do you say in order to bring yourself within F? Do you say there has to be a conscious choice?
Yeah, there has to be. There's a series of components. But one of those components is there has to be a choice between two alternative courses.
But you
objective choice, or a choice that's actually subjectively addressed by the person who approaches it?
Well, I don't say subjectively, because I'm not entirely clear how an adjuster would ever know that there has been a subjective choice.
Once you're made an offer and you come up with another offer, surely that of itself is making a choice.
Yes.
Oh, it's certainly you're choosing how to...
Once somebody makes you an offer, you can either accept it or reject it. Well, that's a choice.
Well, you must decide how you're going to respond to it, and there's certainly a...
But why do you go there? Surely once somebody makes you an offer, as a matter of objective fact, you can either accept it or reject it, or you can ignore it. But those are all choices.
Well, in that sense, then, of course they are, my lord. And it may be that if that's the only relevant sense, I don't need to spend time on this.
If you look, there are some constraints, because if it was entirely unreasonable, or if it was unreasonable to accept the initial offer, it could be said then, using the language of the Court of Appeal, that you had no real choice, because it would have been it would have been in the context detrimental to accept the offer.
Still be an offer, still be a choice.
There'd be a choice.
Frequently accept unreasonable offers.
There are two distinct questions, aren't there? One is whether there is a choice, and the other is whether the selection of one alternative would lead to an expense recoverable in general average. But we do actually analytically have to distinguish between those things.
Yeah.
I entirely follow that. And there may also be an element, it may be that the quickest route for me is to come to my approach to Rule F rather than to spend time on this, which is, and I see the force of the indication from the bench, but there may also be a question which is what type of choice? What do we mean by choice in this context?
What do you mean by choice?
I mean by choice that that a person decides to take one course as opposed to another in order to avoid incurring the other expense.
He has got to go through a mental process of thinking, here are the two alternatives. I am going to choose one of them in order to minimize the amount that I have to pay in ransom. Is that...
Well, what we're here concerned with, by the way, I know this isn't directly answering your Lordship's question, but what we're here concerned with is what's said to be a choice between negotiating down the ransom and incurring increased voyage expenses. That's said to be that's one choice, and the alternative choice is to say, I will agree the full ransom straight away.
There's not a choice, they're the same side.
No, that's one side of the balance. The other side of the balance is pay the full ransom. That's said to be the choice.
Yes.
The choice between those courses.
Why is that not the choice that they had? Is your point that although they chose one course, they didn't actually reflect about it in those terms? They just instinctively... I mean, are you basically submitting that an implicit choice is not good enough?
What I'm saying is the choice has to be done in order to make a saving or for the benefit of the common maritime adventure.
Yes, but every time the pirates made a lower offer, the people advising the ship owners had to make a choice. Do they stick with their policy of aiming for $1.5 million, or do they accept what is now on the table? That seems to me to be something implicit in what they did every time a new offer came in.
Yeah, and my lord, I'm not suggesting that in the exercise of deciding what your negotiating strategy is, and then executing that strategy, you won't be making choices on a regular basis. I'm not suggesting that. The question arises, is it a relevant choice for the purpose of Rule F?
Are you submitting that they have to say to themselves, I am making this choice because, although it will delay the ship longer, it will get the ransom payment allowable for general average purposes down?
Yeah, what I'm submitting is you have to be able objectively to say that the choice was made in order to save what would otherwise be general average costs. That's what I'm saying.
So if you are unaware of the existence of general average costs, then your choice would never satisfy that requirement.
Well, precisely. That is right. Maybe I need to just rephrase what I say, because in order to make a saving the point is to make a saving for the common benefit. You may be totally unaware of what rules are applicable. You may be totally aware of what regime.
Common benefit.
But
you have to know the existence of the common benefit.
You have to appreciate this is being done for the maritime, for everybody, rather than just for you. And I'll show you.
Who has to realise that? The person who's doing the negotiation?
The person who is making the choice. Now, I will show you.
That seems to me an extraordinary.
Well, the textbook writers say that.
Well, they may do,
consistently.
but it does seem to me to be extraordinary. So if you've got somebody who doesn't know about this and happens just caught up with a parrot, and it does a negotiation and is like this, but doesn't know anything about general average, and then comes back home and said, actually, you know, you can recover something from the cargo owners, the answer will be no, you can't, because although you did a jolly good negotiation, which is the matter of law could in principle be subject to general average, I'm terribly sorry, because you didn't know about general average, you can't get it.
No, but
Is that what you're saying?
No, I'm not saying that. I'm saying objectively.
All right, you have to know not of general average, but you have to know that you were negotiating for the common benefit.
You have to be able to say objectively that this was the choice taken, the course taken, was one that was intended to make a saving,
But you said
and therefore for the
it was
common
intended
benefit.
to make a saving.
Yes.
So-
Sure, it was intended to.
Sorry.
No,
Well, any negotiation is intended to make a saving. If I say I'll do something for 6 million and you knock me down, you're knocking me down to make a saving.
But the saving as against the general average expense that would otherwise be incurred. Now, perhaps, my lords, the neatest way I can do this is to show you, is to jump really straight to the passages which I say give a clue. But the important words in the rule, the really important words in the rule, in my submission, are the words extra and in place of. Because if all we are concerned with in this rule is an expense that somehow avoids general average cost which would otherwise have been incurred, those words simply aren't required. They add absolutely nothing to the rule. It's enough, my lords, to say, for example, that you have incurred an expense. The consequence, whether you thought about it or not, is to make a saving in a general average cost that would otherwise have been allowed, and therefore you get it. But that's not what the rule says. The rule has extra requirements.
But intent is not part of Rule F, at least not expressly.
Maybe not expressly, my lords, but that's a question. I will return to that, if I may.
So it's really the words extra and in place of.
Those are really important words, my lords, yes. For focusing on the rule, that's what we say, those are the words which introduce the requirements over and above simply, did I make a saving? However, whatever I intended to do, whatever objectively was my intention, whether I even appreciated that I had two courses, any of those things, if I make a saving, this is really my learned friend's case, he doesn't quite say it this way, but it is really the nub of his argument, you don't need those words, because if you put a line through it, you end up with the same meaning. So my point is, what meaning do those words have, unless one regards them as adding something on, and if they are adding, what is it they're adding?
But why should we accept that what they add is intent?
Well,
On the face of it, extra is over and above the expense that would have been incurred but for the General Average Act. And in place of is simply expressing the fact that this is a substitute expenditure. Neither of those concepts involve intent.
but if one is concerned with whether an expense has been incurred instead of another,
Yes.
one's then looking at the question of, well, if I hadn't have done this, what expense would I have incurred?
Well, all you have one way of doing that is to show that there are alternatives. Clearly, the alternative to accepting the 6 million demand was to take some time to get it down to something lower. They are natural alternatives. Whether you articulate them or not, these are not things that can happen simultaneously.
That is right, but what's said to be the consequence of that here in this case is, it's not the saving in the ransom that's said to be important, though that's the hypothetical saving. What's said to be the expense which was incurred is the additional operating costs.
Yes.
That's said to be the cost which somebody chose, if that's the right terminology, and I will submit it is, to incur in return for obtaining a reduction in ransom.
Yes.
And it's the point about choice from my argument is that it's difficult to see how there was a choice of any material way to agree to incur those costs.
Well, it was obvious that the consequence of not accepting the 6 million demand was going to be that costs would be incurred over an extended period.
Well,
I mean,
my lord, I don't accept that that is right. And indeed, the Court of Appeal didn't think that was right.
well, how could it not be right?
Because if the Court of Appeal make the same point that the Average Adjusters Association make, that if one returned to pirates in this particular circumstance and said, you've demanded 6 million, I'm prepared to pay 6 million, it does not follow at all that the pirates will simply agree that. Far from it, the Average Adjusters Association and the Court of Appeal make note of the fact that actually it's as likely to lead to an increased ransom demand.
But why does it follow from that the consequence of negotiation isn't known to be a delay with a concomitant operating expense?
Because if one cannot predict what course a negotiation will take with any degree of confidence, not least because nobody before has actually taken this hypothetical course. Nobody before and nobody since has done this. You can't say, therefore, that by taking this course you were expecting or choosing to make this type of saving.
If the pirates offered 6 million, you say yes, there must be a much better chance of minimum delay than if you go back with a much lower offer.
Well, in a sense...
You're certain to have a delay with a lower offer, particularly if it's much lower. With the acceptance, you must have a real chance, it may be difficult to assess, of sailing away having paid the 6 million.
Well, in a sense, the difficulty with trying to predict, and the Court of Appeal make this point in fortifying their view on issue 1, is they say one of the difficulties with trying to predict what would happen is it is all speculation.
Well, the courts are used to that sort of problem, but we always face up to the fact that difficult though it is, our job is to decide.
Well, that may be so, but my point is a construction of the rules which will require in this type of case, and it would be no different in the negotiation with a salvor or a contractor, a speculation by an adjuster to assess...
Speculation. It's an assessment as to causation, isn't it? What would have happened if they'd paid up at an earlier stage? If the extra expense would have been incurred anyway, then it isn't in place of the larger expense involved in paying up earlier, because it would have been incurred even if that larger expense had been incurred. If you can form a view that as a matter of causation, paying earlier would have avoided this detention period, then it's an extra expense incurred in place of paying earlier, paying the larger sum earlier.
Well, of course it's a matter of speculation, my lord. It's a matter of causation, and of course it is possible to form a view on it. But the basis for such a view, in a world where this has never happened before, and where, and I'll show you in a moment, the Average Adjusters Association...
Well, no one's ever paid up early, yes.
No one's ever acceded to the first demand. And there could be very good reason for that, is that is not what you would ever be advised to do. The pirates, as we'll see, start with their high offer, and the ritual dance involves you coming back and a meeting somewhere in between. And that's what's happened in every single Somalian pirate case, without exception.
Because it's always the most sensible choice to make. It doesn't follow that there isn't a choice.
No, it doesn't follow that there isn't a choice, but it does follow that the consequences of taking that choice are uncertain.
Well, I wonder, at the end of the day, we're going to have to construe the words of Rule F. It would help me if I understood what you say the word extra adds to to your case.
Okay, well, let me come straight to Rule F, because I sense that would be the most valuable way to proceed. Can I say just a few words, introductory words, about the approach to the rules generally? Because we do say that the rules have to be read as one scheme. They have to be read. This may not be thought to be a controversial proposition. Indeed, the Court of Appeal, in terms, in the judgment is at page 202.
Well, I don't think you have to tell us that sort of thing, really.
Yeah, I mean, one argument open to you presumably might be that the costs of delay aren't part of the scheme, as we see in Rule C, and therefore whatever extra expense means, it doesn't mean
Yes.
the costs of delay, which is a risk that the owner takes. I can see arguments of that nature, but clearly we must construe Rule F in the context of the rules as a whole.
Well, I won't take any more time up on that subject then. And you have seen, I think, well, you've certainly seen in our written case, how it's ordinarily a feature of matters that are introduced into general average, unless they're part of the numbered rules, that they are the subject of an intentional act. A deliberate act, intentional is the magic word that's in the books, and also in the cases. And intentional has a particular meaning, and perhaps it's just worth bearing that in mind for a moment, in the light of the exchanges I've just had with the court. Can I show you a case called Athelline? It's in the authorities bundle at tab 1.1. And again, we say that you gain, Rule F gains some colour from how you approach the other rules. It's at tab 2. Decision of Mr. Justice Tucker. It's at page 635 for those. And it's a decision of Mr. Justice Tucker. This relates to a case where two vessels were sailing from, it's a wartime case, from Bermuda to United Kingdom under escort, subject of subject to the order of the Commodore of the convoy. A Commodore ahead was attacked, a convoy was attacked by an enemy raider, and they were told to turn back. And they did turn back. And the question that arose is, were they extra costs of effectively a 6 days lost, something that was recoverable in GA? To which the answer was no, because it wasn't a cost which had been incurred intentionally by them, in the sense that they had not applied their mind to the decision to incur that cost. Effectively, they had no choice to do it because they were obeying superior orders. And one gets the relevant passage at page 641.
Yes.
And it's halfway down the judgment passage at 641. I won't read it out to your lordships. It starts in considering whether the case comes within general principles of Rule A necessary. Then if I can invite you to just read through to the end of the paragraph at 642, first paragraph.
Is this an argument that's effectively invoking Rule C?
No, it's not, my lord. This is invoking Rule A.
Yes, but you're saying that there is clearly intentionality in Rule A.
And I'm saying that intentionality involves exercise by someone of his reasoning powers. That's what one finds at the top of 94. And discretion.
It's intentionally reasonably made for the preserving peril of the property.
Correct. It must be extraordinary. It must be made and incurred intentionally.
Yes.
Common safety. So far, so uncontroversial, perhaps. But it's really that picking it up on page 94, my lords, the rule, I think, clearly envisages the exercise by someone of his reasoning powers and discretion applied to a particular problem with freedom to choice decide to act in one or more two possible ways. Yes. Quite inappropriate to describe the blind and unreasoning obedience of a subordinate to lawful orders of a superior authority. Now, and I accept this is the approach to Rule A, and what ordinarily gets admitted under general average, outside the numbered rules, may get, and therefore what we would admit under Rule F gains in any colour from Rule A. Intentionality can be seen to mean more than, if you like, an objective intention. Now, I recognise that whether intentionality has any role in Rule F is another issue. But this is what we mean by intentionality. It's what the authority says. My own friend's right, there's precious little authority, but no one's doubted that.
So basically what this is saying is that general average operates within the contractual framework of those involved. It's where there is action taken freely by one actor or one party to that framework. But if you have an act of prince or act of state intervening and you're ordered to do this or that or stay in harbour and so on, even though that leads to the avoiding of some peril, it's just not a general average act.
Well, how this...
It's quite a long way from this case, isn't
Well,
it?
what it's saying is intentionality involves the exercise of reasoning powers and discretion.
Well, that's apparent from the express language of Rule A.
Yeah.
Well, Rule A simply talks in terms of intention.
Yes.
And it's just, the point of that is to unpack what we mean by that word intentional. Intentional can, for the purposes, can bear different meanings in different contexts. In this context, one sees, to use a word that's used, a degree of agonising is required. That's what this case suggests.
It's a degree of voluntary act.
Yes.
In the interests of the common endeavour. And if you have the Admiralty interfering, it's not a voluntary act, and it's not done in the interests of the common adventure. It's done for high strategic reasons.
Or it's you yourself are not, you have no choice as to whether to do it.
It was quite well described in the argument for the successful defendant on top of page 640 in the second sentence. The master of the plaintiff's ships were only performing their legal duty in carrying out Admiralty orders which they were bound to obey. That really is the point, isn't it?
But it is the point, my
Yeah,
lord.
well, it's a slightly different aspect when you are free to accept the 6 million or not.
Well,
There was no question of him being obliged by law or by superior orders not to.
so that's what we say. That adds a little bit of colour to how you understand it. I'm not going to say anything more about Rule C. You've seen Rule C and you see what role it has. I don't think, and we deal with it in our respective cases. We know that it has two wings to it. Only direct consequences are recoverable, not indirect, and losses arising from delay are irrecoverable. So that's, I'm not going to take you separately to that. Let me take you to Rule F, because that's what's at the heart of this appeal. We say that Rule F presupposes, and I'm going to show you some authority and discussion of this. Firstly, an expense being incurred. Secondly, an expense being incurred in place of, instead of, some other expense which would otherwise be incurred. Therefore, the existence of at least two alternative courses of action. It presupposes that both those courses of action are for the common benefit, and you're choosing one for the common benefit. And it presupposes that the expense incurred is extra, which raises the question, which the books look at, extra to what? What does that mean?
Well, that's what I wish to hear.
Which is my Lord Hodges' question. So those are what we say, and can I, if you find...
Presumably we get some guidance on that from the fact that the expense which it substitutes has to be an extraordinary sacrifice or expenditure intentionally and reasonably made for the common safety to preserve from peril the peril property involved in a common maritime adventure. So that's the starting point. So an extra expense must be something which is substituted for an extraordinary sacrifice or expenditure.
Well, if the comparator is Rule A, my Lord, very often the comparator will, of course, be one of the numbered rules.
Yes, I see.
But if your comparator is Rule A,
Yeah, I get.
that's right.
Yes.
In practice, I'm told that actually Rule F is largely used with comparators with the numbered rules. And comparison with Rule A, it raises more difficulties. One of the reasons perhaps why we're here. Now, I just wanted to show you some of the materials that we say support. Can I start with the latest edition of Lowndes and Rudolph? Can I also explain why you have more than the latest edition in the bundle, because there is some suggestion that that was a rather odd thing. There are two reasons why you have the earlier editions in the bundles. The first is that actually the 11th edition is the relevant edition for the 1974 rules. The rules changed in 1994, therefore the discussions are slightly different. The word additional instead of extra. That may or may not make a difference, but it makes it legitimate to look at particularly the 11th edition, and perhaps even the 12th to see how the editors changed. The other reason is that it was said by my learned friend yesterday that somehow Mr. Corner, who is the editor of Lowndes and Rudolph now, was parti pris, suggested he'd adopted a position. Now, I don't accept that at all. But however, he's only the editor of the 14th edition. He isn't the editor of the 11th or 12th. So one sees a different view being provided by different authors. So there's some value to that. You must decide how much value, but we think there is some value. And of course, one has the value of Mr. Hudson's work. So that's why you have before you more than simply the latest edition. Now, can I start with the latest edition, which is tab 22 of bundle 1-2 of the authorities. I start at page 1086. Now, perhaps easier to see this in some of the MS pagination has been obliterated, isn't always visible. 194 internally.
1086.
1086. 194 internally, my lord. Paragraph F29.
Yeah. Yes.
And then we see one or two passages from this page and the next. The first is that for this rule to have any application, there must be an alternative course of action, which, if adopted, would have involved expenditure which could properly be charged to general average. Now, pausing there, my lords, the phrase we see consistently used by the commentators is an alternative course of action. My friend used an expression yesterday, course of expense. That's not the relevant question. The relevant question is a course of action, and what expense is consequent upon that. And that bears on another point he made yesterday.
Well, so far as there's a difference, alternative expense is more consistent with the language of Rule F.
Well,
it may not be, there isn't a difference, in fact, between those two approaches, but if there is.
But a course of expense, my lord, is not a very
helpful
expression.
Leave course of out, alternative expense.
Yes. I have no difficulty with that. But alternative, it's a series of options. We pick it up at 1087, next page. Paragraph F30, F31.
Yeah.
Alternative course should be one that is physically possible in the circumstances, should not lead to frustration on grounds of delay or cost, nor should it be a breach of the contract of affreightment or threaten the legality of the adventure. And then, perhaps more importantly for present purposes, it should be a natural and logical alternative, not a matter of artificial invention. And then the author comes up with a ground. This is all to support the proposition that one needs an alternative course of action that is a real course, a different course. Can I take you now back earlier in the text to the, as I promised, the 11th edition, which is the relevant edition for our rules, tab 20. Page 966, internal page 154. Starts at F22 in the left-hand bottom column.
Is
It's the passage that begins, so if your lordships have it, the fact that there may be two ways of doing a particular job and two prices. This is under the heading, general heading, and I have in mind my Lord Hodges' question earlier, any extra expense. We see that at the top of F21. And you see there it says, the fact that there may be two ways of doing a particular job and two prices does not automatically make the apparent additional expense one method over the other as a substituted expense. If a ship owner would normally take a course of action when no general average was involved, it is to be doubted whether the cost of the same course of action at a port of rescue should be treated in any different fashion. And then an example is given to do with the position in relation to a passenger or cargo liner, which we see at F22, and I won't read that out. But effectively, it says if you do that anyway for your own purposes, well, then it can't count as an alternative course, as an extra expense. And the position is summarised, if I may, at page 2 pages on 157 of the text, F26. Accordingly, it is submitted that an expense incurred by the ship owner will not be extra or substituted if, for instance, it is one that he would be obliged to incur under the terms of the contract of affreightment, or one that he would normally incur for his own interest and benefit, even when no general average situation was present. An expense can probably be said to be extra or extraordinary only when it can be shown that the ship owner has put himself out for the benefit of the cargo, has made something of a sacrifice, and taken a course of action which is essentially foreign to his own individual interests. So we do see there the suggestion that it is not enough in itself that you can describe it as extra in pure financial terms. It needs to be something other than he would otherwise have done, and it needs to be something of a sacrifice for the common benefit, which is one of the bases of the submission I made to you a little earlier, my lords. And then we see the proposition there is no rule of English law that a person could be called upon towards payment of another merely because he may have obtained some benefit from other person's actions. And then what we see is the authors go through a series of what are said to be common examples or usual examples and consider them against that backdrop. And in large measure, what the effect of those passages is to say is, well, then all the standard substitute expense scenarios fit with this. These are something, as my Lord Mance suggested, these are different ways, perhaps thinking outside the box, of dealing with the problem, the issue, not the standard way, but a different way. And if one does that, and one saves, as a consequence, general average expenses that would otherwise have been allowed, well, then one's in Rule F.
One gets from this, though, does one, the suggestion that merely identifying two alternative possibilities is not enough.
Indeed.
You've got to have, if the one which is chosen is something that would be ordinarily chosen and not in the ship owner's own interests.
Indeed. It's something other than, what I shall say, is something other than the standard course. If the standard course is to incur this expense, that is what you would ordinarily do, well then expenses incurred in that way are not extra. So my learned friend wants to...
My Lord, I'm very hesitant to interrupt, and I'll try not to do it again. But could I ask your Lordships to look at page 966 in paragraph F21 at the second paragraph for this purpose? That is the premise of what the editors take to, of what follows in this edition. and it's wrong in our submission.
Is the words for this purpose?
My Lords, it's the paragraph that starts "for this purpose" on page 966. The premise is that the word extra expense meant in the rule extraordinary expense.
Yes.
I described that yesterday as a hopeless suggestion.
Okay,
Because,
right,
yes,
thank you.
enough.
Yeah, well, then this isn't
I'm
time
sorry.
for submission. Thank you very much. Yep.
And then, in the same vein, can I now ask you to look at the addition that follows? This is the addition whereby the authors, perhaps just picking it up at tab 21, the same authors as the previous edition. Sorry, page 977, my Lord.
Yeah.
Tab 21, 12th edition. Mr. Wilson and Mr. Cook. They're the same authors of the 11th edition. If I can just ask you to turn to page 981.
The internal number?
Sorry, internal number 194, my Lord. 194.
Yes.
At 192, we note that they pick up the point which,
They do. And maybe to start at 192 would be helpful.
well, it's just above additional to what? It's the first
It is.
paragraph in ordinary type, the extraordinary expense point, which we had our attention drawn to a minute ago. Yep.
Indeed, but that reflects the fact that by now, my Lord, the rules have been changed to say additional,
Instead of,
extra. So in 1994, our rule changes from any extra expense to any additional expense.
yes.
Does the French change as well?
No,
No, I don't.
French didn't change.
I don't- I think the-
Dépenses supplémentaires.
French was always supplémentaire.
Yeah.
So that,
Well, it looks as if the change simply used language that was more precise in explaining what had always been the intention.
Indeed. And I'm not suggesting that the change makes a huge difference for these purposes, but so the analysis of additional to what is just as valuable as it would have said if you'd had the heading extra. But you nevertheless still have to ask the question at F24, what do we mean by extra? What sense is it extra? And one sees that at 192 internally, but it's a particular passage I wanted to pick up at 194 internally. Under F28. It's really the second full paragraph. In order to determine whether any particular expense can be justifiably deemed additional, clearly necessary first to consider the supposed standard course. It replaces and establishes that it is one which a reasonable shipowner would normally give serious thought to and be likely to adopt in practice. If such a course would not be adopted by a reasonable shipowner, then the course of action actually taken and undertaken, purportedly substituted, may itself be the standard course, and the costs accordingly fail to qualify as additional or extra under Rule F. In similar fashion, if it's part of the shipowner's regular or routine repairing practice, even when no general average situation is present, to send spare parts by air rather than sea, or to work overtime, then it becomes the standard. And nominally increased cost of these operations disappears entirely. Wrong and unfair to allow under Rule F.
And this is asking the question additional to what would normally have been incurred without the general average event.
No, I think it's asking the question, in what sense, what does the word extra or additional mean in Rule F, my Lord?
Yes.
And then it's saying extra to what would be the ordinary course of action that a shipowner would take in this event.
On the footing, in this case, that there was no piratical hijacking.
No, I don't think that is right, my Lord. I think on the footing that one simply looks to see whether there is a standard way of dealing it. A good example, the air freight, sea freight is an example which it's recoverable only in that context because that's the way you bring yourself within the rules. But it isn't saying, I hear, as I submit, that if you're in a general average situation, the fact that is it is the normal way to deal with a situation, it ceases to be relevant.
I mean, there seem to be two possibilities for extra additional. One is the one that my Lord Sumption's putting to you, that it's expenses over and above what would have been incurred but for the general average event. And the other, which I think you're espousing, but I haven't yet got your definition, which is that it is additional to what would be the normal course of action of the ship owner in accordance with his contract, i.e. that you are saying that he bore the risk of any delay, and that a delay related loss is not an additional or extra expense.
Well, I do say that, but also I say that if in complying with, or doing his best to comply with his contractual obligations, he would take a particular course, and he would do that as the standard approach.
Yes.
Well, then adopting such approach can't be an alternative course. It can't be an extra expense, because it is the expense one ordinarily incurs in that situation. Bear in mind, my lords, that here the alternative expenses are by definition also not general average expenses, unless one can bring them within Rule F. That's your starting point. These are not expenses. Take our case, it's the classical case. The operating costs, they are not general average expenses in any way, shape or form, unless you can bring Rule F to bear. So there is a sense in which if the course being adopted, if the standard course being adopted is a course which is the one you would adopt in any event, we say, well, that...
In response to the hijacking of a ship.
Yes, but we say that the costs, the operating costs...
But on that footing, not even the ransom would be recoverable.
No, the ransom is self-evidently a Rule A matter. Because you're only concerned here, my lords, with Rule F.
Right.
You're saying you're by definition dealing with expenses which are not otherwise recoverable, because if they're otherwise recoverable, you don't need Rule F. You bring yourself within one of the lettered or numbered rules. So we're concerned here with an expense incurred which is not otherwise within the rules. And you're saying, well, if that's actually what you'd have done anyway, well, then you can't describe the expense incurred as extra. Because in what sense is it extra? What is it extra to?
It's extra.
Well, that's really what I've been asking.
That takes you back to the dilemma presented to you by Lord Hodge. One view is that it's extra in the sense that it would not have been occasioned but for the hijacking. What is wrong with that view?
Well, what's wrong with that view, my lords, is losses occasioned by the hijacking are not recoverable in general average. In the same way that losses... I'm sorry, Lord.
That begs the question. Some losses are.
But I think what you're saying is, for example, in the period when the ship has just been captured, a few days delay before the pirates get in touch with anyone. There's no question of negotiation. That delay is certainly not an extra... I mean, it's an extra expense in one sense, but it's certainly not a relevant expense for general average.
Indeed, and nobody suggests it would be. And if the pirates captured the vessel and then for whatever reason decided to leave it again 20 days later, no ransom had to be paid, well, then the operating costs wouldn't be recoverable in general average. They would be occasioned by the hijacking, but they wouldn't be recoverable on any basis, under any rule. In the same way that if a vessel grounds, I made this, and there is prolongation of the voyage and there are extra expenses and costs, in principle, none of that is recoverable in general average. So it's not right, we say, to start from the premise that something is occasioned by the hijacking. That's not asking the right question. One has to say, for these purposes, my learned friends can't get these expenses into any of the rules which are said to be arising from a general average, unless he describes them as a substituted expense. That's the only way one gets in. And so therefore, when asking oneself whether the expense that the candidate substituted expense is an extra expense, it is perfectly legitimate to say, well, what would have been done anyway? That's the only sense in which it can be extra. And that's what the authors are saying here. And that's why they're saying it. Because otherwise one leaves oneself with a position where the word extra has no real meaning. It is simply an expense.
Well, not necessarily.
I mean, one is dealing here, by definition, as you say, in Rule F, with the expense that is not recoverable itself under Rule A
Exactly.
or as a general average expenditure, but is a substitute for something that is.
If
In that, given that it's a substitute, which would not itself be recoverable as a general average expenditure, it seems rational to specify that it must be an expense that is only incurred because of the incident which has given rise to the expense which you are trying to substitute for.
But if that is so, well, there will be very many expenses which would not ordinarily qualify in general average. If as my Lord Mance points out, and is undoubtedly right, unless one has this negotiation over the ransom, there's no suggestion that any of these operating costs could be recoverable.
Yes.
So in those circumstances, those are costs which were going to be borne by the owner as part of, in any event. And they wouldn't be any way of...
The point that Lord Sumption is making to you is that they wouldn't have been born if it wasn't for the fact that they enabled the sum under A, as it were, to be reduced. That's the point.
Well, the operating costs would have been borne
Well,
for the whole of the period of the seizure, however long that may last.
that's put in a very tendentious way for the purpose of this argument.
Well, my Lord...
If the court were to conclude there would have been 5 days of holding if they came up with the 6 million, then that would be a very tendentious way of putting it.
No. If it is said...
You say it's of a type that wouldn't have been.
But it's certainly that, my Lord. And I didn't...
Why should it be given that limited meaning?
I'm sorry, my Lord?
Why should it be given that limited meaning? Why should it be limited to expense of a type that wouldn't have been included?
Well, that comes to a different question, what's meant by in place of.
Well, that may be a different question, but
Yeah.
asking it.
Okay, well, but we say in place of, and we've already seen it in references to this, it involves a choice between alternative courses. Courses which are, and we'll see that Lord Justice Hoffman, as he then was in the BLO, making clear he agreed with the proposition there had to be practical alternatives and real alternatives. And we see that one's looking at the situation of there being two distinct courses of action. And the question arises, and it was really a question I think my Lord Sumption raised yesterday, is for the purposes of this rule, can this rule apply if you're fundamentally doing exactly the same thing you would have done anyway, but doing it a bit differently?
I mean,
that's really the question.
I think the passage at F28 where we started is difficult to follow in its terminology, but there is an underlying point which is perhaps helpful to your argument when it says it's clearly necessary first to consider that the supposed standard course of action it replaces, and I have a problem with the word standard, is one which a reasonable shipowner would normally give serious thought to and be likely to adopt in practice. If we ignore the word standard, I mean, because the comparison under Rule F is with another exceptional, intentional and reasonably incurred exceptional expense, not a standard expense. But if we ignore the word standard, you clearly do have to start to consider first whether the supposed course of action which is being replaced is one which a reasonable shipowner would normally give serious thought and be likely to adopt in practice. And if not, then the course of action actually undertaken and purportedly substituted, and then again it says may itself be the standard course, but that appears to me unrealistic. I mean, it may be a very exceptional course in terms of the standard performance of the contractual voyage, but leave aside that oddity of terminology. The extra expense may be one which is, so to speak, one which the shipowner is bound as a result of the original hijacking to incur, and accordingly, it says accordingly failed to qualify as additional. Again, it's odd, it seems to me it's still additional, but it's additional to the normal voyage costs, but it's simply not one which is in place of another expense which would have been allowable.
Well, that may be right, and again, it takes me
This
back.
whole reasoning seems a bit odd to me.
Well, it may be that the word, and again, it's breaking components down, it may be the word extra has to bear its meaning once it's read alongside, incurred in place of another.
But it clearly means extra over and above the normal voyage costs, doesn't it?
Well,
just as the expense which it is substituting has to be extraordinary in relation to the normal voyage costs, you'd expect extra, even if it doesn't quite have the force of extraordinary, to mean something which is over and above the normal voyage costs.
It's certainly that, my lord, yes. It's certainly over and above what would normally... but I would say not simply... Our case is it's not simply a question of saying, well, because your operating costs might have been a bit less in total if there hadn't been a seizure. It can qualify as extra.
No,
I would say, well,
because that's not what F is saying. F is talking about substitution for some other general average expense.
Yes.
So you've got to go through the whole rigmarole. You can't just say we were delayed.
No, indeed. That is my point, really. And once you read the extra with the in place of, you find yourself in a position of saying, well, this is simply prolongation for a particular reason. These are costs that would have been incurred. In that sense, they're not additional. They're not in place of, in the sense of taking an alternative course.
It would help me if I could have in a sentence or two what you say extra or additional means. Extra expense. I mean, is it, as Lord Sumption suggests, is it expenses over and above what would have been incurred, but for the hijacking, or is it something else? If it is something else, what is it?
It's not. You won't be surprised to hear what Lord Sumption suggests.
Well, what is it?
Oh, it is over and above what a ship owner would ordinarily incur
in response to a hijacking.
In response to whatever the situation it is that he finds himself in, whether it be a grounding, a hijacking, whatever it may be. Because you've got to read the rule as it applies generally.
But again, that slightly begs the question. If, as a matter of fact, the court says, had he paid the 6 million, he would have been off within 2 days. But because he negotiated, he was there for another 50 days. Then why isn't the other 48 days extra?
Because also encapsulated is extra isn't simply, it relates to the type, not simply the quantum of it.
Why? Why do you get that out of the word extra?
I get that once you read extra with in place of, and that's where in place of and the alternative nature of the courses comes in.
Why does in place of lead to that conclusion?
Yes. In place of presupposes, we say, effectively, put aside for the moment whether it's a conscious or unconscious choice, but a choice as to how to deal with the situation you'll find yourself in.
It's a bit odd to say, sorry.
No, please.
A bit odd to say I'll pay you £2 instead of £10 is your basic proposition. You can say I'll pay you £2 instead of going to the cinema with you tomorrow, but and those are different things.
They are different things, and I say...
In what context one would say that?
I won't suggest any, my lord. But
the cinema with the poets.
And one does gain some assistance from the fact that if one looks at all the examples that one sees in the texts, and we'll have a look at them if needs be, they are all alternative courses of a different kind. There's no suggestion, for example, that if you do permanent repairs this way instead of that way, you can regard that carrying out permanent repairs as two alternative courses. If you negotiate slightly better terms with a repairer than you might have done if you'd spent a bit longer or applied your mind to it a bit harder, well, suddenly you can say those are alternative courses.
Yeah, so I mean, you would say if you go to a voyage, if the other side are right and the ship is taken to a place for either permanent or temporary repairs to enable her to complete the voyage, and 3 or 4 days are spent negotiating about with shipyards, try and get a better offer. The costs, wouldn't they be allowable anyway, those costs, I suppose?
Well, they may be. They may be allowable. If you're in a shipyard, you might be. If you're in a port of refuge, they would be. If you're in port, they would be. You can imagine scenarios where they wouldn't be. For example, take the salvage instance.
Yes.
If she's still aground,
yes,
she's still in peril, the general average cost will be the cost of your salvors. If you negotiate to get, if you're in some far-flung part of the globe where you can't get your standard LOF terms, and the local salvor reckons that they can charge onerous terms because they're the local salvor. If you spend time maybe trying to create competition, seeing if others can come in, do it much more cheaply, you could create a situation where, for example, you spend 2 or 3 weeks, you achieve much better terms. Yeah. But in those circumstances, if my learned friend's right, the result of that is that one would recover the operating costs for that period. But
you say in those circumstances one couldn't?
Indeed.
Yes, I see.
And one way to look at it is to say this. Well,
yes, I see.
What are your alternative courses here? My alternative courses are to pay a salvo, to arrange salvage services and pay a salvo, or to arrange salvage services and pay a salvo. It's the same thing. The only distinction are the precise terms you've achieved.
This is the argument that we concentrated on when we were looking earlier at the Court of Appeals judgment.
Indeed. And in large measure, this is the Court of Appeals approach. Right. This is their rationale, is to say, well, fundamentally, you're doing the same thing.
That's better.
And if you are fundamentally doing the same thing, well, then the costs which you in fact incur are not in place of, instead of, or in substitution for, the hypothetical alternative costs, because you are doing the same thing. And I made the broad submission earlier that if one's only really interested in incurring an expense, let's just assume for a moment that incurring involves enough of a decision to do it, and a saving, that does leave open the question, what words do in place of mean if at the time that you do it, you don't have to be doing it instead of something else. In fact, you're doing the very same thing. You're just doing it slightly differently. So a ship owner who is trying to obtain best terms available from a salvor, which may be what he ought to do anyway, it certainly might be the standard course, it may be what under Rule A, if that's what he's going to seek relief under, is what would be expected of him, somehow can then say, having done that, I could actually have settled with the salvor for slightly more, and the additional time I spent, I'm entitled to a contribution for others. And just test that question out. How does that, quite apart from the legal difficulties of how that can be said to be in place of, how would that work in practice? How would an adjuster determine at what point the salvor's demand became reasonable? And at what point would one determine, therefore, what the expenses became substituted or alternative? And if it's all a matter for the adjuster to adopt as a matter of impression, wouldn't one be left with a great deal of inconsistency and uncertainty, different adjusters being able, in effect, to come up with completely different results, perfectly legitimately, in trying to determine what a reasonable point in time would be? And in a sense, and perhaps I'll show you, the Court of Appeal thought that that was a powerful point even in the context of the piracy. They thought it was a powerful point that one might have to ask oneself the question, in the context of the piracy, at what point did the pirates' demands become sufficiently reasonable that you might expect them, you would be expected, then you'd be legitimate to accept them. And Lord Justice Hamlin, I'm sure you've read the passage, puts forward, I think in paragraph 47, 5 different anomalies. But one of those anomalies was the situation in which the original demand was clearly excessive.
But don't you have that problem under Rule A anyway?
No.
Well,
The only question in Rule A, you're looking at not what might have happened, what would have happened, but what actually did happen.
yes, but you're also asking the question whether the expenditure was reasonably incurred.
Yes, by reference to the facts as known.
Yes.
But the problem, the difficulty created by this approach is the adjuster is operating not in what happened, but in a counterfactual world, where he or she may have to decide, in a counterfactual world, at what point something would have been reasonable, in order that something qualified as an alternative expense. And one gets, if I can just follow through the example, if one has pirates whose initial demand is, for example, on a facts of our case, $12 million, something that was on any view excessive. It may be that the original demand was excessive anyway, and I'll come back to that. But just at 12 million, imagine a circumstance where it takes, say, 40 days for them to get down to 6 million. The first time when it's even close to the value of the matters in interest. And then shortly after that, you get down to the ransom figure that we have here. Now, on my learned friend's approach, the first 40 days don't count. They can't count. Because it isn't something that in any way relates to a general average expense that has been avoided, because it never would have been allowable. So you have a scheme of rules that says the more greedy the pirate, the less the ship owner gets by way of contribution from others. Now that's a very odd rule to have in place, but that's the effect of my learned friend's contention. That effectively, it's all critically dependent on this, and we say it is an artifice, this proposition that it all depends upon the period of time where the negotiation over the ransom takes place. Because what opens the door, the only thing that opens the door to Rule F in this case, according to the adjuster, is the period of time spent negotiating over the ransom. And it is difficult to see, my lords, how that is anything other than it creates difficulties. Other difficulties could arise. Take the pirates who choose not to actually make a formal demand for a week or two. They take their time. That obviously leaves the ship owner in a very different position to one who receives a demand straight away. Why so? What scheme of rules would justify that? Might that be an indicator that a construction that leaves you in that place is perhaps not the right construction? So, if the nub of the issue is does an alternative course have to be a course which is different in kind? Those are submissions designed to say, well, these are good reasons why real difficulties arise if they're not different in kind. Both on these facts, but they would also arise on the other sort of circumstances in which they would take place. And a scheme of rules, construction of the rule that led to those things, we say, suggests a rather unlikely construction. And at least some of those points were said to be of significance by the Court of Appeal. I was going to show you one or two other passages from the materials. I appreciate that I've tried to do my best to answer questions as we've gone along, but I'm also keen to show you that the position that I put forward is one that is also supported by the materials. Can I show you Hudson? If your lordship still have bundle 1, 2 out, page 941, can I start at?
941.
941, internal 63.
Flag.
So 18, my lord.
Internal 63.
Yes, my lord. Paragraph 11.26.
So this is 941 in what? Which bundle are we?
Sorry, bundle 1, 2.
Oh, 1, 2, sorry.
It's the bundle of the textbooks, my lord. And it's 11.26. Not every enhancement in cost that is to be considered as additional, submitted in order to qualify for consideration, incurring of the expense has to be motivated by a desire to save time, not to one which is a shipowner is committed in circumstances beyond his control, and or he would in any case adopt as part of his normal repairing practice. Now that's in the context of repair, but the principles, we say, are just as good generally. And then at 943, I'm not sure 943 adds very much. It's really 11.28. It's a repetition of another course of action available. Then at 944,
Yep,
1133,
yep.
although Rule F is phrased in terms which refer to the incurring of expense, its application presupposes a choice between two and sometimes more different courses of action. If one of those courses of action, say to effect permanent repairs in the ports of refuge, would open the door to allowances, and then he explains how it works in a particular way, but different courses of action.
If you had to pay somebody commission to negotiate the repairs, and the commission was based on the amount of time they spent in the negotiation, then presumably would that be part of the recoverable cost if they negotiated for much longer because you were getting a better price than if they negotiated for much shorter?
Well, it would depend what you were negotiating over, but if
Well, negotiating over the price.
If one was to negotiate over a ransom,
Well, no, over the price of
no,
repairs.
I don't believe it would be recoverable in those circumstances, no.
You could recover the cost of the negotiator, no?
Not ordinarily. There may be special circumstances, but not ordinarily.
Because
Because it wouldn't be regarded as something which was a sacrifice that was being, because the vessel...
the cost of negotiation and the kidnap, then?
Well, it may all depend, my lord, on whether the repairs themselves would be, this hypothesis,
All
would
right,
be
let's say-
recoverable.
Let's say the cost of negotiating with kidnappers.
Now, the answer to that is it may well be, but that's because it is a Rule A expense itself.
And therefore the extra expense of negotiating the price down would be recoverable.
Well, only if the price itself is recoverable in general
Yeah.
average.
Yes.
That would be the logic of that.
Yes, I see. Thank you. So your case is it all would fall within A?
My case is,
Would all fall within A?
if at all.
No, I understand.
If A is your source of general average allowances.
Oh, well, that's what I'm saying.
Yeah. Now, there are two authorities that deal with Rule F. We saw Western Canada yesterday, and you saw the Biella yesterday, or the Bigella yesterday. The Bigella is quite important because in the Bigella, Lord Justice Hoffman, although he is dealing with different rules, expresses some clear views on the meaning of Rule F. And to that extent, there is some value to be gained from that. We're now in Authorities 1.1. Tab 9. I'm showing you it in the Court of Appeal because that's where Lord Justice Hoffman's judgment appears. The essential facts is a vessel left Providence, Rhode Island, and she grounded shortly after departing.
Page 75. Thank you.
She put into a different port for temporary repairs. And the issue was whether the costs of would be recovered under a particular rule. It's Rule 14, which provided for a regime which is a little bit like a substitute expense regime. Both at first instance and in the Court of Appeal by a majority, it was said no, but in the House of Lords it was said yes. But it's perhaps just because this is worth looking at on issue 2 as well, worth showing you how this arises now rather than having to come back to it later. But the relevant rules are important here. So I'm looking at page 753. The relevant rule you can pick up in the head note is Rule 14. And we are concerned in this case with a case of what's called accidental damage. So it's the second paragraph of Rule 14, where temporary repairs of accidental damage are effected in order to enable the adventure to be completed. The cost of such repairs shall be admitted as general average without regard to saving, if any, to other interests, but only up to the saving in expense which would otherwise have been incurred and allowed as general average. And then here are the magic words that allowed the House of Lords a way through, if such repairs had not been effected there. So the proposition, you have to assume they hadn't been effected there. The rule mandates that you do so. And in the end, that was the approach in which the House of Lords adopted. And then you have to compare that with the costs that would otherwise have been allowable, which would have been in Rule 10, which one sees on page 754. And it's 10A. It's when a ship shall have entered a port or place of refuge in consequence of accident, which render that necessary for the common safety, the expenses, etc., shall be admitted. And the magic words there are necessary for the common safety. And the approach that Mr. Justice Hobhouse, as he then was, concluded was, well, you couldn't find a saving in this case because you couldn't say that going into the repairs at a port of refuge under Rule 10 were necessary for the common safety because you could carry out the temporary repairs. And the argument that was developed and caused Lord Justice Hoffman to consider was whether one, in the context of the interlinking of those two rules, one needed to make some sort of assumption. Because otherwise, when would it ever be necessary to carry out repairs if you could carry out alternative temporary repairs? Now, for present purposes, which is Rule F purposes, I just wanted to show you page 763. Because in his judgment, Lord Justice Hoffman considered the substituted rule principles and in the 763 left-hand column, he begins with a passage which explains the original introduction of substituted rules in Rule 10D. I don't think we need to look at those now, but I only mention them to you because that is the context in which he comes to the passage, which I do want to show you. So if it assists in due course, you may want to read that yourself, my lords. And then, more to the point for present purposes, he then, on the right-hand column, picks up the passage with the expression, the two cases in Rule 10D in the 1890 rules were generalized in Rule F of the 1924 rules. And then he quotes the rules, and they were then in the same form that we are concerned with. So he quotes our rule. And then Lord Justice Hoffman says, this generalized rule seems to contemplate that the hypothetical alternative would be a course which the owner was at least legitimately entitled to take. And then he quotes Lowndes' 11th edition, the edition you've seen, an alternative to or in substitution of what prima facie might be thought to be the normal or standard means of dealing with the given situation. So Lord Justice Hoffman positively suggesting that the passage I showed you was right, carries on. What is less clear is whether all cases falling within Rule F must exhibit the features I've identified in Rule 10D. In particular, is it necessary the course of conduct giving rise to the substitution expense should have fallen outside the obligations of the contract of affreightment? Is it sufficient that the expenditure was a less usual and more expensive way by which the owner complied with his contractual obligations, e.g. to repair the ship? Lowndes and Rudolph suggest that the expenditure of a less kind could fall within the rule, but F, like 10D, certainly contemplates there was a practical alternative by which the adventure could have been completed. And then importantly, for the second issue, he goes on to say, it does not require one to suppose that the circumstances in which the owner made his choice were different from that which they actually were. So what Lord Justice Hoffman is saying there is the sorts of assumptions you might require to make in the other rules, you do not have to make in Rule F. And we may come back to that when I deal with issue 2, but the passage, my learned friend showed you yesterday, the passage on the next page, 765, where Lord Justice Hoffman suggests a solution to the particular problem which he faced, but you do not face, because you're concerned with Rule F. But one sees there Lord Justice Hoffman identifying different courses, practical alternatives, and something more than the normal or standard means of dealing with the given situation. And we say that's all support for the submission I make about the alternatives having to be real alternatives, different kind, something different. So that's that case. The other case I wanted to show you, and I think you saw it yesterday, really, was the Western Canada case, which...
The dissenting judgment.
It's the dissenting judgment. Yeah. And we see that in the same file.
Yes.
Flag 15.
Thank you.
It's easier to read the internal pages than it's only possible. Page 86.
Thank you.
And the significance of the dissent is that when the Supreme Court overturned the matter, Justice of Appeal Shepherd's position was effectively upheld.
But they did they say anything about this?
They didn't expressly deal with
Quite.
What one might call the motive point. They deal with the extra point, though. And the issue in that case on extra was the ordinary course to use air freight anyway, so that an air freight charge as a kind was one that it was not extra, or it was air freight, the use of air freight not the ordinary course in this type of situation, and therefore the normal course is use of sea freight. See, this is an old case and the world has moved on since then, such that the charge can be regarded as extra. And the logic of that, my lords, or the express rationale of that, and we see this exactly being adopted by the court in the Supreme Court of Canada, is it's asking the question, if it has to be extra, it has to be extra to the standard charge, something different in kind to the standard charge. Not enough that you pay more air freight, it has to be air freight rather than sea freight. Now, the case has a value because it is that rare beast, a decision on Rule F. But it shows that, it's going to be my submission, that if you look at the limited authority we have and the text we have, they all support the approach adopted by the Court of Appeal of saying there has to be a choice between alternatives of different kinds. The alternatives cannot be the same thing. And to that extent, this idea of choice has to be a choice between different alternatives. And the word extra must be read as, if you like, just reinforcing that idea. And we say extra in that context means extra to the standard course. It won't be extra if it is costs of the same kind that you would have incurred anyway. So those are my submissions on how you should construe Rule F, which allows me to just pick up 1 or 2 points, if I may, from my learned friend's submissions. And then, subject to any questions your lordships may have, I'll move on to issue 2.
Very helpful, thank you.
Just picking up 1 or 2 points, it was said in my written case, shall I say our written case, at page 157. Of the core bundle, paragraph 95, that somehow we were not supporting the reasoning of the Court of Appeal.
Well, your argument that you've just been putting forward, I think, rather does.
Indeed it does. But my point really is, if one looks at paragraph 95, what we're saying is...
Well,
it may be...
Well, going to be helped by analysing a paragraph of your written case. The question is, what are your arguments? And you've made it clear what they are.
Thank you. Well, I won't develop that. There's no need to do so. I invite your lordships, I won't do it now, but I invite your lordships to look in the passages in Lowndes and Rudolph at how they analyse, and Hudson does the same thing, how they analyse all of the, if you like, the typical substitute expenses cases. And the analysis is one that is consistent with the submissions I've been making. It may well be that I've picked up a great deal of what I wanted to say by way of response to my learned friend, and it might be that there's a limited assistance because you know what I say. Yep. So therefore I intend really to... I've made my point about the construction of the language.
You want to take a moment to go through that, because we have asked you quite a few questions. You want to...
No, but
don't hesitate to take a moment to check.
I think I know exactly...
Fine.
In that perhaps it's just worth just underscoring my point. If we look at Rule F itself, 442 in the core bundle.
Four,
442, my lord. This is a point I made orally, but it's easier to make clearly with the document in front of us. I'm sure your lordships have in mind the language. But my point is this. One sees in the first line of the rule any extra expense incurred in place of another expense which would have been allowable as general average. My proposition is that in the end, my learned friend's submission is one that allows the rule to work perfectly well if you delete the word extra and delete the word in place of another expense, which would have been allowable as general average. Because one simply has an expense shall be deemed to be general average without regard to saving, if any, to other interests, but only the amount of the general average expense avoided. Effectively, if you incur an expense, the effect of that is to lead to a reduction in what would otherwise be general average. Well, in those circumstances, says my learned friend, I think this is the effect of his submission, you're in Rule F. But the point of the submission is to demonstrate that it's a construction that gives no meaning or additional meaning to the words incurred in place of another expense or the word extra. And we say that word and those words are to be read together. And that's what sheds light on the true meaning of Rule F. And it is those words which cause the commentators, and such as they are the authorities, to speak effectively with one voice.
Of a different kind of expense, so something by definition which is not the same kind of expense which would have been allowed in general average, because if it was the same kind, it would have been allowed
Indeed.
general average by itself.
Indeed.
I see.
Now, perhaps it's just worth showing you, Lord Justice, the points, the anomalies that Lord Justice Hamlin raised. I dealt with these, I think, orally, but it's perhaps just worth seeing them. It means I can deal with them quickly now, but I think it's worth drawing attention to them. It's at page 212 of the same bundle.
Yep,
Paragraph 47, my lords.
yes.
And Lord Justice
So
Hamlin...
which page are we on?
I'm sorry, I'm sorry, my lord, 212.
Page 20, is it? Yeah, that's right. Yep.
And it's Lord Justice Hamlin identifying anomalies that arise effectively on the construction that the owners put forward. And those anomalies include, and I've already identified perhaps the most significant, the first and the fifth.
MS.
I've dealt with the fifth, and I won't repeat that. That's the point about the greedy pirate. And why should you have that? The first raises a question, which I indicated the Court of Appeal accepted was far from clear. How do you show that it would have led to a release? And they say that that form of speculation itself, even the learned judge described what would happen as speculation. That form of speculation is one that you wouldn't expect the rules to invite. Now, one understands that there are sometimes occasions when courts, perhaps even adjusters, have to do their best to assess what might have happened. But we say if what's being invited is true speculation, well, then that's an indicator that that's not what the rules mean. And then 2, 3, and 4 are all really about this question of the way in which, in a sense, it is a construct. It's an artifice that depends so much upon the timing of a demand and a response, and leaves in a situation where ship owners gain a contribution or they do not, depending upon either matters that are outside their control altogether, what the pirates decide to do, nothing to do with them. On one view, the whole negotiation is something that is outside a ship owner's control. The people who hold the trump cards are the pirates. You can't force the pirates to agree. You can't make them agree. You can't bind them to an agreement. Only when they choose to agree will you effect a release. So, in that context, it might be thought to be rather odd that one determines what others contribute by reference to something which, by definition, the ship owner cannot control. And that leads to another point the Court of Appeal made, which is this. The reality, we say, of the situation is this. In a piracy situation, you may be faced with theoretical options of abandonment or trying to retake the vessel by force. But in reality, your choice in this kind of scenario, your option, is to seek to negotiate the release by agreeing and paying a ransom. certainly what everybody has done thus far. And if one takes that choice, well then, as the Court of Appeal says, well, once you've started the negotiation will then take its course. You, as a party to a negotiation, cannot control when it will end. You can seek to influence it, but you cannot control it. It is a bilateral exercise and not one that is governed by any legal system. In the end, the negotiation will end when the pirates have agreed a figure they are content with, the lowest they will accept, as against the owners agreeing a figure, the highest they will pay. And that is the point which every negotiation will reach, and it will end at that point and not before. And if one sees a negotiation in those terms, that's just another way of saying, of course it's the same course. Because every negotiation will take precisely that course. What ends up being the pirate's lowest number and the owner's highest number will be a matter of discussion and negotiation. But to describe them as different courses is unrealistic, even more unrealistic than it would be to discuss discussions with commercial parties, contractors, as it may be, where you may have some control over what you do. You may even have legal remedy to it. But here, the most one can say is if one adopts a different negotiating position, you might get a different answer. But the reality is the answer will be the same. The figure may be different, but the answer will be the same. The lowest the pirates will accept, the highest you will pay. That's just another way. And that's what Lord Justice Hamlin means when he talks about no forks in the road. That is where a negotiation ends. That is the nature of the process. And that's why it is the same course, not an alternative course. And as a matter of analysis, there's a lot of force to that, we say. And we say it also avoids the sort of speculative exercise that we say would be inappropriate. It's also the position adopted by the Average Adjusters Association. You'll have seen in the Statement of Facts and Issues precisely what they say. Their position is that a reasonable figure, what would be allowed, is that which is the product of the negotiation. That would be allowed under Rule A. And this takes us a little bit into the second issue, but as my Lord Mance indicates, the issues do overlap somewhat, because the in place of requires it to be in place of something that's allowable. Now, briefly, if I may, can I deal with my learned friend's objections? And I'll do this as quickly as I can. Now, my learned friend has made some objections to some of the points that I take. Now, not that I'm going to read it out, but we have done a very short document identifying where the points have previously been taken in the litigation. I'm simply going to hand it to your lordships. I don't propose to do more than that. My learned friend has seen the document. All I wish to say about these points is this. Perhaps you should see the document before I... What we sought to do is simply group together the nature of the objections. My learned friend's list was rather longer, but by reference to what he picked out yesterday orally. And there's a series of points he makes that we have never said that this is an extra expense, he says, or at least that's not open to us. The intention argument is not open to us. Paying first, not a logical alternative, not open to us. Rule C informs Rule F, not open to us, and speculative nature of the exercise. And my first observation, before one gets to the detail, my lords, is that all these points are aspects, in our case, of the true construction of Rule F. We are not saying here, we're not seeking to say that there is some, however you construe Rule F, we should win for another reason. We're saying these informs the true construction of Rule F, and they relate to passages either in the text of the rule itself, or indeed in the text that we've seen, and therefore the submissions I've made. So all of these are arguments of law. They're arguments about the meaning of Rule F, and as you see from this document, in various shapes and forms, they have been considered in this litigation before. In the Court of Appeal, it's quite right that I hung my hat on one ground, but I hung it because I took the view that that wrapped up everything. The ground about alternative courses wrapped up the construction of F adequately. And indeed, the Court of Appeal themselves, for example, in considering that ground, consider, for example, whether the payment of the first amount would have taken place, whether it was a logical alternative, whether it was speculative nature of the agreement to pay the first amount, and we saw that at paragraph 47 of their judgment. So we do say, A, these points have been live, B, they're wrapped up very clearly within the first and second issues in this case, because this is all about what Rule F means. So therefore, and I don't believe there's been any suggestion, apart from perhaps not having time, of any prejudice caused. It's not as if there's an evidential lacuna of any kind that's being suggested. So we do say that you should approach this much in the same way as Lord Justice Hamlin approached the matter in the Court of Appeal, where he effectively said, I think it was raised below, but even if it wasn't raised below, there are points that can be dealt with and should be dealt with. And we say that's the right course for you. My lords, the reality of this is that the importance of this appeal depends upon you construing Rule F and providing guidance to those who have to apply it. It would be an extremely odd thing indeed if you weren't allowed to construe important parts of Rule F on the basis that it said they weren't advanced below, especially when, as I indicate, they were. So unless you want some more help on that, I wasn't going to say any more about that.
Very well.
So, can I turn to issue 2? Now, this raises, it's been formulated as a discrete question, and it assumes that owners agreed immediately to pay the initial sum, and indeed have paid it, because otherwise the expense wouldn't have been incurred. So that's the hypothetical assumption you have to make. And the issue is, would that be allowable in GA? Now, as formulated, the question really is, would that expense have been one that was reasonably incurred? Now, it is helpful, we say, and you can find it in our printed case at page 153 to 4, to have some touchstone against which you assess reasonableness.
Which paragraph?
My lord, it's at paragraph 80, my lord. And it's postulating the test. The true test seems to be what course of action might a prudent person controlling the voyage at the time adopt, having in mind all the relevant circumstances existing at the time, including the terms of the contract, the interest of all the parties concerned, but without obligation to consider the interests of any one as exclusive. And that is a passage from the Stagline case. And it's adopted by Lowndes as an appropriate test, and we say it is an appropriate test. So the question when deciding whether something is reasonably incurred is to ask the question, well, what would a prudent person, having in mind all the relevant circumstances, have done, having regard to everyone's interest? One might think that's not a very controversial test, so I'll leave that there. We say the payment of the initially demanded ransom would be unreasonable for 3 reasons. Firstly, they're interrelated reasons. Firstly, it is a course that is likely to maximize the cost that all parties to the adventure will have to bear in order to secure release. I say likely, not certain to, because the pirates may put their demand up, but is likely to maximize. So far from trying to reduce the overall cost, it maximizes it, and it maximizes it in a particular context. Now, we'll look at this in a moment, because you need to look at what the average Justice Associations say. But it's a context in which Somalian pirates have consistently began the process by demanding a figure and negotiating down from that. That's not, I'll show you the material to justify that insofar as I need to. But in effect, everybody knows that the first demand is not one settles for. So you would be agreeing to a demand which the person making the demand himself regards to be high, excessive.
Is one allowed to take judicial notice of the likelihood that that's the case?
The likelihood that what's the case, Madam?
That the first demand will be more than the person expects to get?
Well,
or would accept?
I will show you some material in a moment, my lord. I ask you to do that on the basis that there is, as I say, a pattern, and a well-established pattern.
I would assume that your answer to my question was going to be yes, but you say it's more common.
Well, the answer is yes, but actually you've got a basis to be really confident of that here. The second proposition is that in this case, it's not in the least bit clear that to do so would in any way minimize the risk at which the ship, minimize the peril. And there's some material, and I'll show you in a moment, if there is an established modus operandi of the Somalian pirates of negotiating, if the standard way of acting is to negotiate down, if that is the way that everybody expects you to behave, if you behave for the first time ever unpredictably, differently, far from making the process less risky, you may be making it more risky. But you can certainly have no confidence that you're making the situation any better.
Well, presumably the first reaction to an acceptance would be likely to be, look, we didn't ask for enough, and we'll see if we can get make life difficult and stall a bit and get some more.
Well, indeed, one might expect the pirate perhaps to wonder if he'd rather underestimated what he had captured, whether it had a greater value than he thought, whether there's something about what he's captured which is much more valuable than he'd realized, and may well lead to a response which says, well, and that has the capacity, at least, to enhance the risk. It may not do so, but it may do so. And adopting the established pattern, almost certainly, we don't know because we don't have the evidence in this case, almost certainly the sort of pattern that one would be advised to follow when one appoints one's ransom advisor, would normally be the better, safer course. So not only are you paying more, but you're paying more for no obvious or tangible benefit. The third proposition is that there is no evidence in this case that the ship, the cargo, or the crew was any more imperiled by adopting a process of negotiation rather than paying up straight away. There's no indication that there was any particular feature of this capture and seizure which meant that a different course would be justified to the one ordinarily adopted. If there was a particular feature, well then I'm sure we would have heard about it. But there's no suggestion of anything, and there's no suggestion that the extraordinary course of acceding to the first demand was somehow justified by extraordinary features. And my final point is that the one case-specific factor that is relevant to reasonableness is the values of the cargo in the ship. Now, you will have seen from the statements of facts and the printed cases that actually the value of the cargo and the vessel and the interests as determined by the adjustment was 5.4 million, i.e. less than the first demand. You will also have seen that at the time of the negotiations, the owners took some advice on values, and they were given a range of possible values. And that range gave rise to a possible values of between 4 and 7 million.
Sorry, say that again.
Between 4 and 7 million. Sorry, I'm corrected, 5 and 7 million. And the median figure, if one simply, well, the median figure is what it is, obviously so, was 6.35 million. Slightly above the initial offer. But of course, any owner would know there was a meaningful and strong chance that actually the values would be less than the initial offer. If the median figure is slightly above, well then there's a just under a 50% chance that actually the values will be less. So in the range of considerations, this was a high demand as against the value of the ship and the cargo. So the only case-specific factor that is of relevance here is one that militates against the acceptance of the initial offer as being a reasonable act, or, to use the language that we shown earlier, a course that the prudent operator would adopt faced with these circumstances. And there are other considerations too, wider considerations, like, for example, if we exceed immediately, what does that say in the future about encouraging piracy, endangering ship owners? And the ship owners themselves would have that same interest. If they ply their trade through the Gulf of Aden, they would not be wanting to encourage pirates to feel that they perhaps next time should demand more. Now, all of those considerations make an expense of the first amount demanded one that would be a sum that was not reasonably incurred. And the sole issue on the second issue is that question. Now, the principal point that's said against me, really, is that this has all been decided below. This has been decided below by the judge and by the Court of Appeal, and because they've decided it, it isn't really something which you should interfere with. But bear in mind, my lords, that it's been decided in a rather curious sense. It is by definition a counterfactual. There is no evidence of any kind directed at this question. I haven't got a witness who speaks to it. I haven't got any documents that speak to it. The learned friend is anxious to point out we didn't have any expert evidence. So actually it's all a question of really the issue before the court and the Court of Appeal was to do with what legal standard am I applying to a set of undisputed facts. What do we mean by reasonably incurred in this context? They aren't interpreting any factual material, because there isn't any factual material that's relevant. Because, unsurprisingly, nobody in fact applied their mind directly to this. And if they did, they certainly haven't told anybody they did. So this is not a case where the finding is one based on the evidence.
You might be saying that they did apply their mind to it, although I know you say there's no choice, but nonetheless, they unhesitatingly went down the path of negotiation, as your
Yes, well,
course, which might be a pointer to the question whether it would have been sensible or reasonable.
indeed. Well,
not to do that.
insofar as there's any material, the material suggests that the sensible and reasonable course was to negotiate. And when I say in our written case that there must be a degree of latitude applied when determining how you look at Rule A in the context of Rule F, by which I mean determining whether the hypothetical expense saved is reasonable or not, what I mean by that is simply the mere fact on its own that you did not do it is not decisive. Rather like it was regarded as decisive in the Bigella, because the test there was necessary, I accept that there may be more than one reasonable response. And for that reason, there needs to be given some latitude. But even allowing for that latitude, my submission is the payment of the initial demand is not a reasonable response. And it really applying the test we've seen, I've articulated. So those are my reasons for saying it is unreasonable. I've dealt with why reasonableness is open to me. Your Lordships will know the Henderson and Foxworth case much too well, and I won't take you to it, but that's the case about
Yes.
when things can be reopened. Which leaves really, as the final question under this issue, what's been described as the Hudson conundrum. And whether in effect there is some, if I call it this, a constructional solution, which allows Rule A and Rule F to be construed in such a way that that which would otherwise be regarded as not reasonably incurred has, by method of construction or perhaps even implication, to be regarded as reasonably incurred. And even articulated in that way may identify the difficulty with the process. But that's why I showed you earlier when we were in the Bigella, Lord Justice Hoffman's observations. What's being suggested is that one has to make an assumption that the ship owner was in a different position to the circumstances he in fact faced. Well, my learned friend is quite explicit. This argument draws its inspiration, I think those are his words, from Lord Justice Hoffman's judgment. Well, as inspiration goes, it's pretty thin, my lords, because Lord Justice Hoffman himself says it does not apply in Rule F. Because Rule F doesn't require you to do the exercise that you might have to do with the interpolation of Rules 14 and Rule 11. Rule 10, I think. So, as a starting point, it seems most unlikely. And I showed you that earlier. Now, the Court of Appeal, we say, dealt with this point clearly, and we say correctly. One can pick up what the Court of Appeal say. It's in the core bundle at page 217. It's page 217, and it's Lord Justice Hamlin, paragraph 71 of the judgment, addressing why there was no justification for adopting what I'll call the Hoffman approach. And I needn't read it out, but the propositions are, you can't ignore Rule A, why should you? Yes, there's some flexibility, and that flexibility means that the problems you got under Rule 10b in the Bigella simply don't arise. Rules 14 and F are materially different. I've made that point. the general context and applicability of Rule F is different to the specific context. So note, my lords, that whatever you say about Rule F has the potential for a much wider application than it does in the numbered rules. And there's no necessary, it's not simply not necessary to make the assumptions to give the rule business efficacy. It can work perfectly well. It is workable and works without difficulty. And so far as we are aware, nobody has ever suggested otherwise. There may be something of a conundrum in the sense that it would be wrong to say that we accept that because a different course was taken, the course that was not taken is inherently unreasonable. That's the only sense in which one needs to import some latitude. Once you've taken...
It slightly depends on the question which Lord Justice Hoffman didn't answer, in particular whether Rule F is contemplating situations where you step outside the reach of the original contractual arrangements or a normal course of the voyage or something like that.
Yes.
You obviously do to some extent, but
Yep.
if there is, in other words, a prima facie obvious way of
Yes.
completing the voyage in its original intended fashion, then the premise of Rule F seems to be that that is going to be reasonable, but there may be some exceptional extra way of avoiding it by extra expense.
There may be, quite right, my lord, there may be an alternative course,
Yes.
a different course,
Yes, a different
by which you may adopt, which would avoid that expense, incur other expense, and if you do so and cause an overall saving to general average, well, then you're within Rule F. And that is to regard the whole of, that's to, if you like, take the whole of the issue of Rule F rather than split it into the two parts. Now, I'm conscious that there are two things I wanted to show you, and they relate more, I think, to the reasonableness question, but they are, I wanted to show you the Average Adjusters Association decision, because it is, we say, relevant, because it informs the proceedings, it informs the dispute between the parties, and it informed the courts below. So if I can just show you that, my lords, it's in the core bundle. It's at page 423.
Four, two, three.
423, flag 7.
Thank you.
8 flag
Yep,
7.
yep. Thank you. Yep.
And the form of it, it's perhaps just worth mentioning the form of it, because it's not the most obvious document to understand. It is, what we see at 423 is a submission that is made effectively by my clients to the association seeking a guidance on the question, and the whole of that submission, that is to say, the point that's been asked for a ruling upon, continues onto page 424. And then one picks it up thereafter with the association convening a panel, and then it makes its ruling. And at 425, we see the panel consider whether rules 10 or 11 could apply, and that's what I alluded to yesterday orally. And then at 426 is where my learned friend showed you yesterday, which is, does it arise in Rule F? And the proposition the adjusters say no. I just wanted to pick out 2 points that may be of some relevance when one considers issue 2, which is at page 435. And these are, just so you, again, context, this is the appendix which sets out Mr. Madge's dissenting position. And in order to understand it again, one needs to look at the ordinary type is Mr. Madge's position, the italics beneath it is the riposte by the majority.
Yes.
And at paragraph 16, Mr. Madge, the dissentient, and the relevant passage for present purposes is the first two paragraphs.
Sorry, which page is this on?
Sorry, page 435, my lord.
Yep.
Paragraph 16. Mr. Madge, clearly the ransom amount initially demanded cannot automatically be allowed in GA. One has to go through a reasonable period of customary negotiation to reduce the ransom. And then further down, that's Mr. Madge expressing in italics the position of the panel. And again, I'm not going to read it all out, but the important point is really the final sentence of their first paragraph. The panel members could not recall any instance of a ship owner paying the first figure demanded by pirates, and considered that such an early accession would simply be met by a demand from the pirates for a still higher figure.
Yes.
And that's something that the Court of Appeal placed some significance upon. So what I take away from that is what I said a little bit earlier about there being a standard way of dealing with the piracy situation, a negotiation that is customary, and that you would be stepping away from that custom in acceding to the first demand, which is a point I made in relation to issue 2. And that's put vividly in a passage. You were shown this yesterday from Mr. Well, perhaps before I go to that, can I just show you another authority which helps on Somalian piracy? This is the Bunga Malati Dua. The authority is 1.1 at tab 11. Now, this is a insurance case arising in the context of Somalian piracy. There was a capture which takes place in August of the previous year, and the issue that arose is whether the cargo was a constructive total loss. And one of the questions that arose is whether there was any prospect of the cargo being recovered. And for present purposes, I don't rely upon it for that issue because it doesn't arise in our case, but it does set out, and both of the courts below have looked at this, a great deal of useful material about piracy in Somalia, and looks at it as at the position that would have predated our capture. And I'm not going to read it all out, my lords, I'm just going to tell you where I think you may find assistance. Page 775, paragraph 12. 12.
Yep.
Through to 14. Maybe 14 specifically.
Yes, I see.
It was all of a piece. Process of negotiating demand. Actual prospects of recovery very good.
Did he hear evidence, Mr. Justice Seal?
Did he hear evidence? Yes, he did.
How do we treat this? Because I think there's a technical objection.
There is a technical objection. I think the courts below have treated this as confirmation of what we see in the Average Adjusters Association, something that allows you to take comfort that the Average Adjusters Association position does reflect what was happening in Somalia. I say it's relevant because if you're to decide what was reasonable in all the circumstances, one of those circumstances is, well, how did Somalian piracy operate? What was known about it? Because we know that the ship owners did get specialist advice on this subject. And we don't know what they were told. They haven't shared that with us. They've chosen not to share that with us. But it's a reasonable inference that they would have been aware of those matters which were in the public domain as at this time. So it's somewhat artificial to, we say, to ignore matters which are sufficiently well known, as long as they're sufficiently notorious. I acknowledge details you can't place any reliance on. So that's why we say you get some assistance from.
Well, ship owners are a fairly, I suppose, tight market, or quite well informed on issues. This is, so you say, this can inform their thinking as to what the right course would be.
Indeed. And more than that, my lord, they took specialist advice, and the chances are the specialist advice were especially well informed. We can't know for certain, but it's a reasonable inference. And again, I'm not going to read it out, but paragraphs 19 to 22 may assist insofar as they relate to what was known in August 08 about how these types of matters proceeded, perhaps paragraph 22. I'm not suggesting that this document was before anybody, but this type of knowledge is quite likely to have been.
Well, it was certainly a well-known case at the time.
Yeah, indeed it was.
This case.
Indeed it was. And then at paragraph 26, one sees Mr. Justice David Steele setting out the effect of some expert evidence being given. And again, there is a process. One sees there's a typical profile at subparagraph 3, a passage that was quoted by Lord Justice Hamlin, though in quoting it, he missed out an important word. He quoted safest, most timely, effective means to secure the release of crew in such circumstances proven to be to pay a ransom. Well, he missed out the words to negotiate.
Well, where's that?
Sorry, it's in subparagraph 3 of paragraph 26. To negotiate and subsequently pay a ransom. And one sees typical detention periods in Romans 7. I don't need to develop this further, but it fits with what we say is a reasonably established, what's called modus operandi, and that's, we say, something of which you can reasonably conclude the ship owners would have had some knowledge, not perhaps detailed knowledge, but some knowledge. And finally, on this subject, just a document that my learned friend showed you yesterday, which was the paper produced by Mr. The paper that reflects a seminar given by Mr. Tomlinson. Give me a moment and I'll find the reference. Tab 20. Sorry, it's authorities 1, 2, tab 20.
Tab 20.
Tab 24. Now again, I only point to this because it's of a piece with what you've seen. It's at page 1104. I'm not reading it all out to you, but you see about a third of the way down, we see Mr. Tomlinson is discussing issue 2. But what I wanted to point out to you is the passage 3 paragraphs up from the bottom, really. Somalian piracy follows well-known protocols. We know how it works. On average of about 50 days, they reach an agreement and ransom is paid. To what extent an initial demand would be negotiated down could be predicted and with a high degree of accuracy. In other parts of the world, it might be appropriate to attempt to haggle, but in the context of Somalian piracy, they're expecting to negotiate. Every single case has gone, you introduce stability into this situation instead of introducing an unpredictable element. That fits with what I was saying a little bit earlier. It may be that I don't need that to support the submission, but I make the point that that fits with.
Understand.
So, let me deal finally with 3 broad points, and then I will have concluded my submissions. 3 broad points are made against me on this appeal. One is it said that my construction of the appeal works unfairness. It said that it's unfair, somehow contrary to natural justice, to prevent the ship owners from recovering the amounts which they say they expended. Well, there are a number of answers to this. First is an answer that was explored a little bit yesterday in submissions, which is to say, well, others will also potentially suffer losses during this period, particularly cargo, may or may not suffer losses caused by prolongation, and we know from Rule C they will not be able to recover such losses. So why should there be a different position for ship owners than there is for the other parties to the maritime adventure? What is unfair, what is fair about marking one party out with an exception rather than the others? Secondly, on the facts of this particular case, but not actually, but in many others, the ship owners themselves are not making the sacrifice. The time charterers who made the sacrifice. That will be very often the case, that the party who's actually paying the ransom is not actually bearing any of the risk of delay. The fairness point starts to lose some of its force in that context, insofar as it ever had any force. And the third point about fairness is the one that appealed to the Court of Appeal, which is that actually the rules themselves are a balanced regime. They provide for what they provide for, and they do so in a deliberate way. Obviously, you have to decide, my lords, what Rule F means and how it works. But you should not be influenced by considerations of fairness, because you may be importing into the rules something which nobody intended to be there, and effectively disturbing a settled and effective regime. So don't be influenced by that. The second point generally made is one of incentives. My learned friend suggests that somehow, if this appeal is not allowed, ship owners will be disincentivized from negotiating down a ransom. We say that's a very odd submission indeed. In almost every case, certainly in every case before this incident and every case after this incident, ship owners have not needed that incentive to negotiate down a ransom. It's what they have done in every case. They have very good reason to do it in any event. It means they're minimizing their first outlay. It means they're minimizing their costs. So the idea that a ship owner needs to be incentivized is somewhat fanciful. But secondly, it doesn't operate as an incentive in this type of case, because the ship owner is not paying the price. The time charter is. So the ship owner has no reason not to negotiate, whatever the outcome, the disposal of this appeal. So there is simply no force to the incentivization point. And the final third point my learned friend made and started out with was he said that there was a certain inconsistency in our position. The inconsistency was said to lie between the difference between the approach to Captain Gantz's expenses and indeed the ransom consultant's expenses and to these expenses. And it was said that somehow that those were all Rule F type expenses, and how could we object to those? Well, those expenses, as the adjustment itself shows, and we needn't turn them up, but at pages 321-2 and 331-2 of the bundle, were expressly allowed under Rule A.
Yep.
And has never been suggested that was the wrong allowance. And indeed, they are very different in kind to the operating expenses with which we are concerned. They are specific costs which were in fact deliberately incurred, and they were deliberately incurred for the purposes of seeking to achieve the release of the vessel. And to that extent, one sees how they fall within Rule A, and one sees how they're quite different to that which we find in this case. So there's no inconsistency of treatment. There never has been. If there is an inconsistency, it's one that the adjuster thought was commendable. So did the commercial court judge, and so did the Court of Appeal. The Court of Appeal, when dealing with media expenses, thought they were firmly Rule A expenses. So there is no inconsistency. So that again, is no reason not to influence your outcome. Subject to being told there's anything I haven't said, that's all I wanted to say. Unless I can assist you further, my lords, those are my submissions.
Thank you, Mr. Crowell. Tom. Kenny, I think probably a sensible course is for us to start again at 2 o'clock, is it? Unless there's anything you particularly want to
No, my lord.
bringing in our ears as we go off to lunch. Very well. Well, you will have half an hour at 2 o'clock.
Thank you very much.
Court's now adjourned.